Lordship, may I have your kindly to mention
Yes.
it is intra-court appeal
Ah.
that 148 notice issued without maintaining any procedure. Even the sanctioning authority has given the approval under section 151 directly in a one line, my lord. There is a judge. The Delhi High Court.
Sir, you want to appeal to issue?
Yes. Sorry, my
Yes.
Maybe public to mention a judgment was delivered by your lordship on 6th of May 2025, by dint of which, my lord, the Food Corporation of India was directed to pay damages in favor of the writ petitioner respondent, my lord. After that, my lord, the Food Corporation had filed a review petition, and by dint of pendency of the review petition, they are not making the payment, and they have not taken any steps for listing of the review applications. Great.
I give leave to mention the matter of the Cricket Association of Bengal, your lordship. If it may
You
be
just bear with me for this week. Huh?
My lord, may I return? On 4th July 2025, Lordship was pleased to pass an order in connection with a writ petition. There is an CAN application for clarification of your Lordship's order. Pursuant to that, my lord, there, my lord, now the dispute is, my lord, further clarification of your Lordship order, because, my lord, they are trying to occupy my own premises and carve up Durga Puja.
Lordship, may I be permitted to mention one matter, Your Lordship? Your Lordship, on 5/8/2025, you have passed an order, Your Lordship, where the name of the council has been missed, Your Lordship. And
My lord, kindly allow another matter. On 13 August, I mentioned that I am arguing on the point of scope of 35G. My lord, your lordship may remember, your lordship was pleased to direct to listing for
That
this
is
week.
that wagon.
Yes,
Wagon.
and it is not updated in the still. It is 14 August, so it may be listed in this week, my lord.
May be permitted to take leave, my lord, to file without certified copy.
Date of the order?
7 July, my lord, 2025. We have applied for certificate.
7th July will be out of time. No? 7th July will be out of time. So you have to file section 5. Have you filed an application for certified copy?
Yes, my lord.
We will direct them to issue the certificate copy. No? You will get it today. Yes, please call.
Original side daily list item number 1.
Look, this appeal was admitted, my lord, on 8 questions. What is the first 2 questions are regarding the rate of corporate guarantee fee, and the rest are regarding the valuation of power, the captive power plants, what should be the value of the power which is captively generated and consumed in the manufacturing unit. So that the group of questions regarding the power part, that is now concluded by judgments of our court. This case of Star Paper, which my lords, which is followed by the tribunal here, and my lords have been pleased to affirm the view taken by the tribunal. And latest one is that Rumta mine. So those questions 3 to 8 are fully covered, which my lords are pleased to admit.
So questions. Where is the admission order?
That is on 31st of January 2024, my lord.
Admission order.
So which are covered by that Star Paper?
Roman 3 to Roman 8 are all relating to that valuation of power.
So that is covered by these 2 decisions.
Yes, the Star Paper and I've got copies. As far as 1 and 2 is concerned, the assessee had offered to be taxed on the fee of 0.30%. But the transfer pricing officer made it 0.69%. That was because the assessee had taken into account the comparables with credit rating of BB. The TPO took into account comparables having BB plus and BB minus. So the Commissioner Appeals held that no, you cannot take into account BB plus, BB minus. Just confine yourself to BB. and in which case 0.30% is all right. The revenue preferred appeal against that before the tribunal. Before the tribunal, the learned departmental representative cited a decision of the tribunal where 0.50% was upheld. Following that decision, the tribunal has made it 0.50%. There's no question of law there. They cited a decision, and on the basis of that, now they're questioning the 0.50% also.
So it's a revenue which cited the decision.
Yes, ma'am. Okay, if my lords are pleased to take note, page 63. In fact, not page 63, the discussion starts. Page 64, the last 6 lines. We also carefully perused the decision furnished by the learned DR in the case of Rose India, wherein the coordinate bench has held that where a corporate guarantee to benchmark was issued by on behalf of the arm's length guarantee fee would be 0.5%. Considering the facts on record and perusal rival submission, we are of the view that it would be reasonable if corporate guarantee fee of 0.5% is applied to the benchmark international transaction. So there, what rate essentially is a question of fact. The commissioner appeal not.
But then it is their own submission before the tribunal.
Yes,
0.5% is something revenue has proposed, my lord, and had shown that judgment. Now
the
revenue
tribunal
seem to be not
they should have been
dissatisfied.
on appeal. The assessee should have carried the matter.
Yes, yes. The revenue seem to be dissatisfied even with the rate which revenue has itself proposed.
And this is Rungta, is it?
On this part, on the power part, if my lords are pleased to see the tribunal's order, the material portion is at page 72. They, I don't need to trouble my lords much, but kindly take at page 74, where they say in the second line, the said view of the assessee is squarely covered by the 2 decisions of the honorable benches, namely Star Paper and Balrampur Chini. So they follow Star Paper. The controversy.
And Star Paper has been affirmed.
Yes, Star Paper. There were 2 matters decided by our court. One was a detailed judgment, and the other one, following that, it's a short order. Sorry. My lords are looking at Star Paper, then on page 2,
that is IT 8214.
My lords. But page 2, the last 6 lines.
Page 2 of the
the reported
lodgement.
The last 5 lines for the purpose of taking a decision merits. Then, my lords were pleased to refer to the judgment of the Supreme Court in Jindal Steel.
Yes.
And then in Rungta Mines, if my lords are pleased to have the reported decision. Paragraph. Rungta Mines, the reported decision, paragraph 14, page 8 onwards.
Other side,
paragraph 14.
14 onwards, my lords were pleased to.
In this also we refer to this ITC.
Yes, ma'am. ITC in the Star Paper.
Sir, please come. This appeal filed by the revenue under section 260 capital A of the Income Tax Act 1961 within bracket the Act is directed against the order dated 29th August 2022 passed by the Income Tax Appellate Tribunal C Bench Kolkata within bracket Tribunal in ITA number 1989/KOL/2019 for the assessment year 2015-16. The appeal was admitted on 31st January 2024 on the following substantial questions of law. We have elaborately heard also. It cannot be disputed by the revenue that the substantial questions of law 3, 4, 5, 6, 7 and 8 or Roman letters small are covered by the decision of this court in the case of Principal Commission of Income Tax versus Star Paper Mills Limited 2025 172 taxman.com 391 as well as the decision in Principal Commission of Income Tax Central 1 versus Rungta Mines Limited 2025 176 taxman.com 410. The ratio of the said decisions being that where an assessee transferred power from its captive power plants within bracket CPPS bracket close to non-eligible units and benchmarked transactions using internal CUP method, CUP capitals method, adopting average annual landed cost of electricity paid by its manufacturing units to state electricity boards within bracket ACBS bracket close comma since CPPS were established for captive use and not for sale to SEBs, comma internal CUP was most appropriate method for determining the arm's length price. Take a note. The relevant paragraphs of the judgment are quoted here and below. Paragraph 14 to 21. In the light of the above decision, the substantial questions of law 3 to 8 are answered against the revenue. This leaves us with the first 3 substantial questions of law, which relates to restricting corporate guarantee fee at the rate of 0.5% as done by the learned tribunal in the impugned order. To test the correctness of the decision of the learned tribunal, we have carefully gone through the findings recorded from paragraph 6 of the impugned order. And we find that the revenue had placed reliance on a decision of a coordinate bench of the Mumbai tribunal in the case of Rose India Private Limited versus DCIT 2021 127 taxman.com 591 within bracket Mumbai tribunal bracket close, wherein the tribunal held that where a corporate guarantee to benchmark was issued by on behalf of the associate enterprise, comma, the arm's length guarantee fees would be 0.5%. The tribunal took note of the facts of the case and also the submissions made on either side and held that it would be reasonable if the corporate guarantee fee of 0.5% is applied to benchmark the international transaction and accordingly partly allowed the revenues appeal, set aside the order passed by the CITA and directed the assessing officer to benchmark the transaction by applying 0.5%. We are at a loss to understand as to why the revenue is on appeal as against the said finding, more particularly when it was the revenue's case before the learned tribunal that the arm's length guarantee fee should be 0.5% by placing reliance on the decision of the tribunal in the case of Rose India Private Limited. Apart from that, we find that the question numbers 1, 2 and 3 as suggested by the revenue also involve factual adjudication which has been done by the learned tribunal And therefore we find that no substantial question of law as suggested by the revenue in questions of law number 1, 2 and 3 arise for consideration. Accordingly, the appeal fails and is dismissed.
But 1 and 2, my lords are not pleased to admit 3 questions on the corporate guarantee, so it will be 1 and 2.
The three I have not at
No, only 1 and 2, my lords.
1 and 2.
Question 1 and 2. I'm grateful.
I'm bored on with your lordship.
Item number 2.
My lord, in this matter, I am for the respondent, my lord. We are the appellant there, my lord. Your lordship, my lord, similar matter in Casta 5 of 25. Your lordship directed the department to refund the interest within 6 weeks. But in this matter, my lord, your lordship kindly takes up page 3 of the order dated 22nd August 2025, my lord. The refund has been, my lord, already been given to them. Only they are entitled to get interest. My lord, your lordship directed us to refund this within 3 weeks, the interest, my lord. If your lordship can make it 6 weeks, my lord, as your lordship passed in a similar matter on the same day, 5th, Casta 5 of 2025. That we are besieging your lordship, my lord. Am I understand, my lord? Similar matter, my lord was directed us to refund the interest, my lord, by within 6 weeks. But in this matter, your lordship directed us to refund the interest within 3 weeks, my lord, within 3 days.
Now the last paragraph,
My lord.
the revenue is directed to effect refund in favor of the respondent together with interest.
My lord, refund has already been given, my lord.
Refund has been
all right.
only the
Refund has-
interest.
So within what time you will
My lord,
My
6
lord,
weeks.
earlier matter directed 6 weeks. In this matter also, my lord, kindly direct 6 weeks.
Lordship, we have no objection.
the matter has been listed under the caption to be mentioned, pointing out an inadvertent mistake which has occurred in the last paragraph of the judgment and order dated 2nd August 2020, which reads as follows. The revenues also, please extract that. It is to be noted that the revenue has already affected the refund. But what has to be now refunded is only the interest component. Therefore, the above paragraphs shall be substituted by the following paragraph. Inverted comma open. The revenue is directed to effect the refund of the interest. No, effect payment of interest in favor of the respondent within a period of 6 weeks from the date of receipt of the server copy of this order. That this order shall form part of the order dated 2nd August 2025.
Grateful, my lord.
We are grateful, my lord.
For hearing of all matters, item number 3.
Lordship, in item number 3, your lordship, I have got instruction from the department to withdraw this matter since it's below the monetary limit, your lordship.
It is submitted by the learned standing counsel for the department that she has written instructions from the department to state to withdraw this appeal on the ground of monetary effect. Accordingly, the appeal stands disposed of on the ground of monetary limit, and the substantial questions of law admitted are left open.
Obliged, your lordship.
Item number 4.
May it please your lordship. This is that matter, my lord, wherein my lord, your lordship had observed that the, my lord, the assessment of my lord, the assessment has been done on the basis of my lord, the search and seizure of a search person, and my lord, there was an issue whether my lord, the satisfaction my lord, that is required my lord, to my lord, proceed against the assessee was recorded or not. My lord, that issue my lord, initially my lord, was assailed by filing a writ petition my lord, and that writ petition was my lord, turned down, indicating that that has been done. Then my lord, that order was my lord, again challenged before my lord, the honorable division bench. My lord, the honorable division bench have uphold the finding of the single judge, my lord. Then my lord, that was my lord, assailed before my lord, the Supreme Court. Now Supreme Court my lord had dismissed the SLP by giving a liberty to my lord raise that issue before my lord, the assessing officer. So, my lord, ultimately it has been held while my lord dismissing the SLP that the satisfaction, my lord, that is required, my lord, that has formed part. That has formed part in the, my lord, the assessment order of the search party. But, my lord, the question of limitation, my lord, that is something, my lord.
Now, please show us that portion of the order passed by the tribunal which has gone against the revenue, because they are also on cross objection. The cross
Yes, there's a
objection
cross objection.
what point?
But on that satisfaction part, no, the tribunal,
Okay, because of the liberty granted.
yes, no, Supreme Court not gave us that liberty, no, that order. The Supreme Court was.
That has been reproduced, my lord, in the order of the tribunal. I'm indicating that to your lordship.
Supreme Court's order is not reproduced, no, that.
So some portion. It's 40 to 49. Page
So
50, my lord.
whatever has happened up to Supreme Court is not going to affect that.
Yes, there are two parts, my lord. One part is, my lord, whether, my lord, the recording of the satisfaction, my lord, Supreme Court had held, my lord, that has been done in respect of, my lord, the search party's assessment order. But with
But
regard to
then, what was pointed out is, where did we made some notes somewhere?
But if I may remind my lords, no,
There were two letters.
lordship,
Yes.
no, I'll just remind you. No, there's a at the assessment stage, no, in the block assessment order, the officer, no, referred to a letter dated 5th August 2003, no, received from the Delhi officer. Delhi officer, no, assessed the searched company, no, Friends portfolio.
Somewhere we noted that dates.
My lords took up this matter on 31st July last. I'm making a mistake.
I'm dictable. That's true mistake. That's why I don't know.
On 13th, Lord, I'm sorry, 13th of August.
All right, doesn't matter. Please give us some facts.
Lord, this search, Lord,
On what date we heard?
13th of August.
13th of August, my lord.
Yes.
But 3rd of August 2000 was the search in respect of a company called Friends Portfolio Private Limited and its director Manoj Agarwal. The director was also searched. Now the assessment, the block assessment in their cases were completed on 29th of August 2002.
2003.
2.
Yes.
But the Delhi assessing officer, this company was in Delhi. The Delhi assessing officer wrote to the assessee's assessing officer, the Calcutta officer, on 5th of August 2003. Enclosing materials and suggesting proceedings under section 158 BD. But I was not the searched person, so therefore not the assessing officer had to be satisfied of the search person that undisclosed income was of the assessee in Calcutta. So then on 28th of November 2003, the Calcutta officer recorded his satisfaction and issued a notice under section 158 BD.
Yes.
No, as far as the satisfaction part is concerned, no, the assessee was contending that 5th August 2003 does not constitute satisfaction. In any case, it is belated. It's almost 1 year after the completion of the block assessment in the case of French portfolio. But at the hearing before the tribunal, the revenue produced for the first time an office note dated 29th of August 2002.
Office note of the Delhi office.
Delhi office, 29th August 2002.
Yes.
This 29th August 2002, in that there's a Delhi tribunal decision where this 29th August in respect to arising out of the same search, there's a 29th August 2002 satisfaction note, which was considered by the tribunal in that.
Antedate. It is antedate.
My lord. So that view was taken there that it is antedated. And against this, the revenue had gone up to the Honorable High Court, Delhi High Court. They did not challenge that particular finding that it is antedated. They went, the High Court was pleased to dismiss the appeal. Revenue's appeal against the tribunal decision was dismissed.
On this ground was not canvassed.
It was not canvassed. Now, there was another case,
that is also reported decision.
Yes, it is 288 IT.
288 IT. Yes.
Now, there was another case of Radhesham Bansal, which travelled up to the Honorable Delhi High Court. But there, the revenue for the first time before the High Court proceeding to service this satisfaction note of 29th August 2002. So it was not even used before the tribunal, it was before the High Court. The submission on behalf of the assessee was that one, of course, it has not been brought on record by a procedure known to law. And secondly, the assessee contended that such a note had been found to be antedated in SMC share brokers. The revenue had come up in appeal and not challenged. So that submission of the assessee was accepted. The court said that 29th August 2002 cannot be relied upon.
Which is that decision?
Lord Shumla, that is, I just.
We have got the copy of this. This is I did your honor to touch. Paper
Draw attention to the relevant portion. If my lords are pleased to have paragraph 13 at page 227. Thereafter, I'll draw attention to paragraph 24 onwards at page 233.
evening executed unlisted leave মামলা পৌঁছাতে মানে কি ধরে
Para 28 also.
Now, this matter my lord, was taken up. This is a group of matters. My lord, the revenue took up this group of matters before the Honorable Supreme Court. Now, that decision my lord, is reported in 362 ITR 673. My lord. If my lords are pleased to have my lord, paragraph 44, my lord, at page 691.
So the individual cases were not gone into.
Lordship, when matter was sent back. Now, my lord, I was able to locate it from the website of the Honorable Delhi High Court my lord, as to what happened thereafter. If my lords are pleased to have my lord, the
Now, upon remand, the Delhi High Court once again followed 337 ITR.
Yes.
As against which no appeal.
against that there's no appeal. I'm not. I checked the website. There's no appeal showing.
So this is, so as of now, 337 ITR finding holds good.
Lordship. Now, my lord, the next day, on the previous occasion, my lord, I had handed up a judgment my lord, of reported judgment in Bharat Bhushan Jain.
Bharat Bhushan Jain.
My lords may have it. My lord, it was decided on the 8th of January. But this other matter was decided on 7th of January. And Bharat Bhushan was decided my lord, on 8th of January. That's a reported decision. And in that case, my lord, the arising out of my lord, the same search, and the court my lord, had at page 697, the court had tabulated the my lord, the date of search, date of assessment. This is all 29th August. Date of satisfaction note. My lords will see my lord, it is from June 2003 going up to my lord, January 2004.
So this is on the limitation.
Limitation part. And then look, kindly see the next paragraph. The court noted the facts. The appeal was originally disposed of by a common judgment, and then they've come back from the Supreme Court.
Imitation নিয়ে কিছু বলার নেই।
They followed Calcutta Knitwear.
And therefore, in these cases, the conclusion is in paragraph 6 to say that delay of 10 months to 1.5 years is too long. It's not immediately after the assessment, and therefore the
Here it is more than a year,
just short of 1 year.
just short of 1 year.
As far as the satisfaction is concerned, 5th August 2003, and as far as the notice itself is concerned, it's after more than 1 year. Notice is in November. With the Delhi officer's letter, which is referred to everywhere, that is 5th August 2003.
But the Delhi officer's letter, there's no satisfaction recorded.
The Delhi officer's letter.
No, he is not required to know.
Delhi officer is required to record.
Because Calcutta Knitwear states,
yes,
last paragraph, in the result, we hold that the purpose of 158 BD, a satisfaction notice signed on, must be prepared by the assessing officer before he transmits the records. So, according to the assessee, 5th of August doesn't record any satisfaction.
But the 5th of August is what my lords are pleased to direct that it should be obtained. But I was able to.
This document we could not upload it.
But he has recorded some satisfaction.
He has written that there's cash was given back. Now the material which was there, that has been examined by the tribunal, and tribunal has said that the records, those papers do not show that any cash was at all given.
Where is that finding?
Kindly take note, page 88. Paragraph 9.3.
Eight, 87.
Oh, it is struck off with the comment cancel.
Yes, and that was also check entry. And with regard to that person, there was a cross-examination, and that person deposed that it was wrongly, the entry was wrongly made, and it was struck off. And he said that I never gave any cash to
that is in para 9.4.
Lordship. He says that Radhesham Bansal gave the cash. Radhesham Bansal, my officer here had issued a commission he had asked that both Manoj Agarwal and Radhesham Bansal be called for examination, cross-examination, that Radhesham Bansal never turned up. And as far as the Manoj Agarwal is concerned, he had, apart from his oral testimony, there's nothing, and he also does not say that he gave me the cash. He has no evidence that any cash was given to me. My case was that he has earned the profit, he has not paid taxes, he's trying to put it on me.
Where are the substantial questions? Your substantial questions. Page.
So the court was pleased to
Admit it.
Kindly simulate
on
the
the question of perversity.
One question.
Sir, please, admission order is there.
25th of April
Suppose
2011.
subsequent for a paper was not included admission order.
Well, subsequent.
25th April.
25th of April 2011, madam.
It is in
So it's as vague as possible, this question.
It covers everything, madam.
It's essentially a question of fact. In my humble submission, it's a question of fact, and assessee was not heard at the time of admission.
And in your cross objection,
Not sure.
it is the jurisdiction.
Not sure. Well, the Supreme Court decision became available after the tribunal's decision of Calcutta Knitwear.
But in the cross objection, you are not required to suggest any question of law.
They are formulated as grounds. There's no question which has been formulated.
What does the tribunal say about the alleged note dated August 29?
The tribunal says that it is that the satisfaction is there. But I was able to, because it was produced before the tribunal, I was able to lay my hands on that as well. My lord had asked of me whether he had. So in my humble submission, this is not a satisfaction note; it's an office note, and my lords may.
August.
Office note.
In fact, this was.
So, what is the date of the order passed by the tribunal? Impute.
In our case, the order is dated 18th December 2009.
2009.
18th December 2009.
But at that time, this SMC share brokers 2006 judgment was available.
But it has been considered by the tribunal. But on this point, it did not refer to the judgment. On merits, it did. But not on this part, it did not consider that. And I went through this note. This office note. I think there are different versions. This 29th August, there are different versions. This was never pressed in aid. In my case, till before the tribunal. Now, because the satisfaction note, my lord has seen 5th August 2003 how it reads. Now, this is a general note on the modus operandi. Then he says, kindly take the new paragraph at page, the second page. The last two paragraphs, in fact, if my lords are pleased to see. in that note of 29th August 2002. Efforts were made by the investigation wing to identify the beneficiaries of these transactions who had taken entries more than rupees 5 lakh from particular bank account in the cases of the companies. On the basis of efforts made by the investigation wing, 158 BD proceedings are recommended in the cases listed in annexes 1 and 2. These annexes also give the prima facie quantum of transaction done by these beneficiaries. Some of these cases are being centralized in this circle, and in other cases, intimation is being given to the concerned assessing officer to take up the proceedings under section 158 BD. In cases where the assessment proceedings are not available, the information shall be passed on to the jurisdictional range additional joint commissioner. Efforts were made during the course of the assessment proceedings to identify the beneficiaries and the list of such beneficiaries along with the quantum of the transaction, and the relevant check number issued to them is enclosed in annexes 3 and 4. Their addresses have been obtained from the banks. This is the list of beneficiaries who have been identified till date. Efforts shall continue to be made to identify the other beneficiaries. In the case of beneficiaries enclosed in the list, information shall be passed on to the jurisdictional range additional joint commissioner to direct the assessing officer to take up proceedings under 158 BD. As and when the other beneficiaries are identified, information shall be passed on to the jurisdictional range additional joint commissioner to direct the assessing officer to take up proceedings under 158 BD. Now, as far as this assessee is concerned, we'll kindly see the next page, annexure 1, in that document itself, the very next page. But serial number 7, KK Daga, serial number 10, SMC share brokers.
But even this is not a satisfaction.
It is not a satisfaction.
In fact, to put it in the words of the decision of Supreme Court in Radheshyam, sort of an imagination or speculation. There's a probability, we have to investigate, we are taking.
Because not in a friend portfolio's assessment order, it was added on a protective basis. So they were unclear even then as to where it will be assessed. Therefore, they said the inquiries have to be made. Now, under 158 BD, it has to be the satisfaction of the assessing officer. Now, annexure 1 is based on investigation of the search wing. It's not the assessing officer's satisfaction. Annexures 3 and 4 are the assessing officer's satisfaction. He says, this is what I have been done in the assessment. But 1 and 2 are not his. So, it seems to me that there are different versions of this 29th August. But this is not, in my humble submission.
That order saying that it's an antedated document has become final.
Yes, that has become.
So therefore, the finding rendered by the tribunal based on that has to be eschewed or set aside. If that is set aside, then you're relying upon the 5th of August 2003, where the Delhi officer has forwarded. Even that we find is not a, or rather, this was considered by the tribunal, and on facts, it has held in favor of this, that there is no such transaction, the check was cancelled, etc. So that point goes. And above that, almost a year.
That Bharat Bhushan,
which the Honorable Supreme Court, where this is
Bharat Bhushan of the Delhi High Court.
Bharat Bhushan Jain says between 10 months to 1 year.
The limitation part is something which is there. Otherwise, with regard to the satisfaction.
Limitation they are entitled to raise because of the liberty granted by the Supreme
Yes, that's it.
That is, at the time when the appeal was admitted, they were not probably
No, that's even the Supreme Court and even the High Court, the point of
is
limitation, that liberty was always there.
So if the cross objection is allowed, your appeal has to be dismissed.
Yes, but the appeal was admitted on the point of the merit of the matter, because this is the search materials.
Absolutely valid question. It's not a question of law.
The satisfactions that was required to be a precondition to initiate this proceeding has been recorded in a search party's assessment order. So and the order.
No, you read Radheshyam Bansal. That's where they explain what is satisfaction means under BD.
Yes.
All right, please come. This appeal filed with revenue under section 260 capital A of the Income Tax Act 1961 within bracket the Act is directed against the order dated 18th December 2009. passed by the Income Tax Appellate Tribunal, B Bench, Kolkata, within bracket tribunal.
May I have your lordship slip pen?
Yes. IT within bracket SSA number 70 within bracket KOL of 2008 for the block assessment year 1991-92 T2 2001-02. The appeal filed by the revenue was admitted on 25th April 2011 on the following substantial question. On what date leave was granted to file cross objection?
My lord, so it was granted, my lord, on 16th of June, 2016, Lord.
By order dated 16th June 2016, the Honorable Division Bench granted leave to the respondent assessee to file cross objection, which has been filed and taken on record as OCOT 6 of 2016. In the said cross objection, the following grounds have been raised by the assessee. I think ground number A, B, D, D for Delhi, E and F. I think that will be sufficient. We have elaborately heard. As could be seen from the above grounds raised by the assessee in the cross objection, the assessee questions the notice dated 28th November 2003 issued by their assessing officer at Kolkata under section 158 capital B capital D of the Act as being wholly without jurisdiction and / or barred by limitation. The assessee places reliance on the decision of the Delhi bench of the tribunal in the case of SMC Share Brokers Limited versus Deputy Commissioner of Income Tax. What is this citation called? SOT means?
Selected orders of tribunal. But these were not reported, but they were, there's a book published where it was. TTJ is a regular, was a regular.
That is better. We'll refer to that. So and so, SMC Deputy Commissioner of Income Tax 2007, that will be within bracket 109 TTJ 700 within bracket Delhi. Though the learned tribunal in the impugned order has taken note of the decision, it has not touched upon the issue regarding limitation, more particularly the correctness of the stand taken by the revenue that there is an office note generated at the instance of the assessing officer at Delhi, assessing officer of the searched person at Delhi, dated 29/8/2002. It is not in dispute that the said office note was produced for the first time before the learned tribunal, which had weighed in the mind of the learned tribunal to decide against the assessee. The Delhi bench of the tribunal in SMC Share Brokers Limited considered the office note dated 29/8/2002, its effect and efficacy, qua the stand taken by the assessee that the said office note was antedated. The The learned tribunal, I think relevant paragraph will be from para 20.
But 14 to
14, the question starts.
and 17, they've concluded that it is not to be taken into account. 17 was at page 10.
Ah. Learned tribunal has elaborately considered the effect of the said office note dated 29/8/2002 and held that on or before 29/8/2002, the assessing officer of Messrs. Friends Portfolio Private Limited and that of Sri Manoj Agarwal within bracket searched persons bracket close did not record any satisfaction, and the said note dated 29/8/2002 is therefore command not to be taken for recording satisfaction required under section 158 capital B capital C / 158 capital B of the Act. The revenue carried the matter on appeal before the Delhi High Court in the case of Commissioner of Income Tax versus SMC Share Brokers Limited, 2007-288 ITR 345 within bracket Delhi. And on going through the judgment, we find that the correctness of the finding rendered by the tribunal with regard to the office note dated 29/8/2002 was not put to challenge by the revenue before the Delhi High Court. Therefore, for all purposes, the decision of the learned tribunal in SMC Share Brokers Limited, where the effect of the office note dated 29/8/2002 stands affirmed as on date, and therefore the revenue cannot rely upon the said office note to mean a satisfaction note recorded by the assessing officer of the searched person / S persons. This aspect was taken note of by the Honorable Supreme Court, taken note of by the Delhi High Court in the case of Commissioner of Income Tax versus Radhesham Bansal, 2011-337 ITR 217 within bracket Delhi. Wherein the Honorable Division Bench held that as the finding of the tribunal in the case of SMC Share Brokers Limited has gone unchallenged, reliance cannot be placed on the office note dated August 29, 2002 to come to a conclusion that there was recording of satisfaction. For the sake of argument, if we consider the office note to be for the sake of if the revenues contention before, please type out the revenues contention before the learned tribunal as well as before us is that the office note dated 29/8/2002 should be regarded as a satisfaction note. The note has a preface stating office note within bracket for departmental use only. On carefully going through the note, we find that there is no recording of satisfaction done by the concerned officer, namely the Deputy Commissioner of Income Tax, Central Circle -3, New Delhi. As there is reference to certain efforts which have been taken by the investigation wing full stop. The statute mandates that a satisfaction note has to be recorded by the assessing officer. And this has been explained in the decision in Radheshyam Bansa. Wherein it was held. So I'm taking from. proceedings initiated under section 158 capital B capital D has been done within a reasonable time, or is it barred by limitation? On this issue, we take guidance from the decision of the Honorable Division Bench in the case of Commission of Income Tax versus Bharat Bhushan Jain, 2015 370 ITR 695 within bracket Delhi, wherein the Honorable Division Bench took note of the decision of the Honorable Supreme Court in Commissioner of Income Tax versus Calcutta Knitwears, 2014 362 ITR 673 within bracket SC, and held that the revenue has to be vigilant in issuing notice to the third party under section 158 capital B capital D, immediately after completion of the assessment of the searched person, and the delay ranging between 10 months of 1.5 years cannot be considered contemporaneous to assessment proceedings, and therefore held the notices impugned therein are not in conformity with the requirements of section 158 capital B capital D, as they were unduly delayed. In Calcutta Knitwears, the Honorable Supreme Court held that for the purpose of section 158 capital B capital D of the Act, a satisfaction note is a sine qua non and must be prepared by the assessing officer before he transmits the records to the other assessing officer who has jurisdiction over such other person, full stop. The satisfaction note could be prepared at either of the following stages, colon, A, small a within bracket, at the time of or along with the initiation of proceedings against the search person under section 158 capital B capital C of the Act, semicolon, within bracket small b, along with the assessment proceedings under section 158 capital B capital C of the Act, semicolon, and C, small c, immediately after the assessment proceedings are completed under section 158 capital B capital C of the Act of the search person. The Honorable Supreme Court in Calcutta Knitwear, after laying down the above legal position, did not examine the individual cases before it. And one such matter which was in the bunch of appeals before the Honorable Supreme Court is in the case of Radhesham Bansal and other connected matters. And the matters were remanded back to the Delhi High Court for consideration of the matter on the legal principles set out in Calcutta Knitwear. Upon such remand, the High Court of Delhi, in the case of Commission of Income Tax Roman 13 versus Manoj Bansal, ITA number 578 of 2008, etc. batch, dated 7/1/2015, considered the matter and dismissed the revenues appeal. Thus, by applying the decision in the case of Bharat Bhushan Jain, we are inclined to hold that the initiation of proceedings under section 158 capital B capital D of the Act by pursuant to a letter dated 5/8/2003 issued by the assessing officer of the search person is barred by time, as it is almost a year after the block assessment was completed on the search person on 29/8/2002. That apart, the assessing officer of the assessee before us had issued notice under section 158 capital B capital D only on 28/11/2003, and going by these dates, it can be safely held that the entire proceedings are inordinately delayed and barred by limitation by applying the legal principle set out in the above decision. Thus, for the above reasons, we find that the initiation of proceedings under section 158 capital B capital D of the Act is flawed, and accordingly the same is required to be set aside, and the cross objection filed by the assessee is allowed. Consequently, the appeal filed by the revenue is dismissed, and the substantial question of law raised by the revenue as answered against the revenue.
I'm grateful. My lords may refer to the Supreme Court order on the SLP.
This one, liberty.
Yes, that part not is.
We have said earlier that the appeal was admitted, leave was granted, so on. At this juncture, it needs to be pointed out that no, please. At this juncture, we take note of the submissions made by the learned senior standing counsel for the department that the matter relating to the searched person traveled up to the Honorable Supreme Court and has attained finality as against the searched person. The revenue cannot place reliance on the decision which was rendered in the case of the search person, since the respondent assessee had preferred a special leave petition before the Honorable Supreme Court in special leave to appeal civil number 27967 of 2008, arising out of an judgment and order of this court in APOT 373 of 2004, dated 12/10/2004, which was filed by the search party. No,
this is, I had instituted this proceeding before our court.
Rising out of so and so. And the Honorable Supreme Court, while dismissing the special leave petition, Honorable Supreme Court, by order dated 2/12/2008, while dismissing the special leave petition, held that it would be open to the assessee before us to show the jurisdictional fact for issuing the said notice did not exist before the appellate tribunal. This after the the leave was granted to file cross objection after this order. Therefore, rightly, the Honorable Division Bench of this court granted leave to the assessee to file the cross objection.
I'm grateful.
This office order, copy was given to the assessee before the tribunal first time.
29th August, it was made over because the chartered accountant had it with him. I got it from him.
Item number 5, my lord, I'm led by Mr. Partho Ghosh, engage in courtroom number 2.
My lord, on the earlier occasion, I requested your lordship to keep it after.
No, what has happened? You please tell us.
Lordship, so far the order is concerned, lordship.
You have filed appeal to Supreme Court. No. You filed. You give the diary number or
Yes,
something.
the diary number is 44.
You write down and please hand over. It is submitted. No, it is submitted. The learned advocate appearing for the applicant is held up before another court and accommodation is sought for.
My lord, maybe there is no stay, lordship.
Pardon?
There is no stay.
That is, you may say so. The learned advocate appearing for the alleged contemnor submitted that the alleged contemnor has filed an appeal before the Honorable Supreme Court against the judgment and order passed by this court in so and so diary number. Let the matter be listed in the second week of September. By then you number it.
My lord, kindly record, they have also filed another contempt before the single bench. May not proceed with the.
Somewhere you will have to get caught, no? You can't extend. If you escape from here, you will get caught there. You escape there, you will get caught before us.
Lordship, on the same order, one
Yes,
contempt
yes,
in
yes.
single bench.
And the single bench will deal, we will deal separately. Next.
I'm the.
Item number 6.
But I'm appearing for the respondent. There was a delay of the SSC of more than 600 days. Not there was direction filing opposition. We have filed opposition. I'm handing over to the document.
You file your reply.
Yes.
Affidavit in opposition has been filed by the respondent department objecting to the delay. Objecting to
6 weeks may be given because party is staying outside Calcutta.
Objecting to the prayer for condemnation of delay. Leave is granted to the appellant assessee to file what is it? Reply, yeah? Reply within 6 weeks from date.
Wait,
that is 6 to 10, no?
Item number 6 is.
No, 7 to 10.
7.
What is 7 to 10?
I am led by Mr. S.N. Mukherjee in the matter.
Pardon?
I'm being led by Mr. S.N. Mukherjee in the matter, Your Lordship. Your Lordship.
There is a delay, is there?
Yes, my lord. There's a
yesterday your-
delay of 188 days.
But yesterday, Your Lordship, there was a delay of 38 days in case of a Benami matter where the department has craved leave to file affidavit in opposition to 38 days, my lord. In this matter, my instructions are to oppose the delay. I've never opposed, but after yesterday, I think department stand is to oppose every delay of 38 days. They are opposing, my lord. I may be granted in leave to file affidavit, my lord.
All right. Let them file. Adjourned by 2 weeks to enable the respondent to file their affidavit in opposition to the prayer for condemnation of delay. 7 to 10.
7.
I'm grateful. Your Lord.
Item number 11.
Well, let's say they are ready, is it? Appellate side, they are ready.
No, this is relating to 8AP. Other year was decided on the last occasion in my favor. This, my lord, there is a technical flaw and I am bounden duty to point that out. So I will not get relief in this case. The question of law is at page number 9. (17B). The same issue has arisen, but this is the second round of the proceedings. In the first round, before the ITAT, the ITAT
ITAT did not grant you this benefit under ATP for house building loan for staff.
even for interest on FDs with banks. So the two items, they did not grant me benefit. So for assessment at 13-14, my lord has decided in my favor one issue, house building loan against me. Now, in this case, even that one issue cannot be decided in my favor because in the first round, before the ITAT followed Todgar. And there was alternative plea that whatever in.
Now this appeal has to be dismissed on the finding recorded in this order. Where is the finding with regard to
ITAT is finding?
No, our division bench, our judgment's finding on question of law number 4. 4 is with regard to house building loan to staff. Three and four.
At page 8, para 12.
No, this you are entitled for deduction. Where is the finding for house building?
My lord, that is at page 10, para 15.
So we will follow this and dismiss the appeal.
And about there are two components. One is FD, interest on FD with banks. So that has been decided here in my favor. But in this case, my lord, I have a technical flaw. I will not be entitled to that benefit also, for the simple reason that in the first round, tribunal followed Todgar, and in the alternative prayer was that any cost has to be from the interest income. I should be entitled to deduction of any cost that I have incurred, like I am paying interest to others also. So for that limited purpose, it was set aside to the AO. And thereafter, the proceedings emanated, and finally, in second round before the tribunal, SSC is taking the plea that I am entitled to interest. So that because I have accepted the first round.
Yes. Please come. This appeal by the SSC filed under section 260 Cap Clear of the Income Tax Act 1961 within. Let's see.
Hello.
Yes, sir.
My lord, your lordship's order
while your lordship was sitting with Honorable Justice Supratim Bhattacharya, your lordship has passed the order in a simple application for recalling, and my lord, the adjourned sine die, and my lord, taking chance of it, my 16 crores property, my lord, has already been, I have been evicted, and my lord, now they are going to dismantle me, that very particular properties on just Tuesday. My lord, then my lord, let the matter be taken up, at least, my lord. My lord, that the on Friday, my lord, because that I am suffering a lot.
No, what you can do is, you please file an application, bring.
My lord, that I have already filed an application. My lord, then I am to file it only because I am the respondent side. I have got an order of stay. And my lord, that even if I've got an order of stay, your lordship's passed order that it is an intra-court appeal. Your lordship has entertained that. But it is not an intra-court appeal. That was a contempt appeal. That was a contempt appeal. Your lordship has got jurisdiction in the contempt appeal, but it is not such. Therefore, my lord, kindly.
Mr. Adhikari, the file is not before us. Whatever you want, you file it in the department, it will be listed. Please.
Oh, my lord, in the department. In the department means that, but my lord, that I am, my lord, that yes, my lord. And my lord, that yes, my lord. And my lord, I am expecting, my lord, that the matter may be taken up on, my lord, that if not Friday, my lord, with Honorable Justice Supratim Bhattacharya. That is well within your lordship's domain. If your lordship will not do, then my lord, that if I will be dispossessed, then my lord, that even my lord, I have taken consultation with my lord, Honorable Mr. My lord, I had been, my lord, in the last flight yesterday. My lord, that and my lord, that Patliwala, my lord, that he made consultation with me that well, you go and move it, otherwise that it will dispense, then it cannot be. Even if it is rejected by your lordship, then my lord, if the application is rejected, my lord, then there is, my lord, that is scope for me to go even.
Appellate side, daily list, serial number 1.
And my lord, I am giving it in writing. A short note in the so that exists. My lord, your lordship will kindly keep it with Supratim Bhattacharya, my lord, Honorable Justice. My lord, that on Friday, my lord. Otherwise, that I will be it will be very difficult.
You have rectified the defects.
My lord, one defect has been rectified as regards to the Vakalatnama, is because the advocate on record before the single bench is the same, my lord. It is we do not file the Vakalatnama, my lord. Normally, usually we do not file the Vakalatnama.
No, it's a separate proceedings. You file your Vakalatnama. We
Right.
pull that. The time granted to rectify the defects pointed out with the registry is extended by a week from date.
My lord.
But we are fine.
Next.
Serial number 2 and 3.
2 and 3 Roshan.
2 and 3. Stay application has been filed.
Yes, my lord, the stay petition is. In this matter, I am led by Manoshi Mukherjee, my lord. I am paying for an adjournment, my lord.
You have received copy of the stay
Yes.
application. Next week we'll have the letter come.
May
You
it be
have
kept
got-
on Monday, my lord.
Oh, one day or 2, 3, 4.
As your lordship pleases.
Tuesday.
Monday.
Okay.
Monday.
At the request of 2 and
Serial number 5. My lord, this is that Benami matter, my lord. Mr. Ghoshal had appeared.
He'll say not today.
My lord, there is one aspect also, my lord. The petitioner, writ petitioner, has filed an appeal against the interim order of the learned single judge. Another application is filed before the honorable single judge
for modification.
My lord, this is the copy. And that is prior to filing of the appeal.
That was not disclosed in the appeal.
My lord, this is the.
And what happened to this application?
My lord, the adjournment was sought before the learned single judge on the ground that the appeal has been referred to before the honorable.
Already today he is not here.
Not here. But my lord, what is the point in keeping this appeal?
Let them come.
My lord.
None appears for the appellant. Mr. Amit Sharma for the respondent.
Respondent number 1, 2, and 3 only.
1, 2, and 3.
Serial number 6.
Not today.
Serial number 7.
Kindly make it not today.
Not
7.
today.
7 and 11 also.
Both matters I am there.
7 to 11.
No, only 7 and 11.
7 and 11 not today.
Grateful, madam.
8 also, my lord, not
8 also. 8, 9.
Serial number 9.
GST board. In Bharia.
Pre-deposit. Pre-deposit.
Pre-deposit, my lord. After the order under section 73 was passed, I could not file the appeal, but I could not pay the 10% pre-deposit. My case for before the appellate authority was that my financial condition is so bad that I cannot pay. This was the case, my lord. This was not considered by a formatted order. No reasoned order has been passed. A formatted order which gives all the options, rejected, this, that, all the reasons are stated there. By such an order, it was rejected. I came before the Honorable Single Judge, who only considered 2 of the challenges. The primary challenge was this, that I was not able to pay 10% deposit. So that should be waived in my case, because this is a special case, a situation where I cannot pay. And in support of my contention, I had made detailed submissions in the petition in paragraph 12 and had also attached a certificate from CA, which shows that my business, which used to be around 26-27 crore rupees, has now come into lakhs.
But what to do? This pre-deposit provision
Is there. So
you have also argued that that's
no, so there my submission is that the legal position as appears to me is that in cases where there is an absolute.
no. You please show us the original authorities order.
Pardon my lord.
Original authorities order. Page 57.
50.
Where is the speaking order?
Speaking order is
57 is order in original passed by the authority.
Speaking order.
The speaking order. Because only thing is speaking is that
59.
Yes.
And the appellate order is page 82.
No, please show what is the finding of the adjudicating, original authority.
That order is page 73, 57, my lord. And the reasons for such order is coming on page 59. Difference in GSTR 1 and 3B, my lord. That was page 61.
And there is since I was in the business of this mobile services, selling these recharge coupon and providing some money transfer services. And there my case was that I am a pure agent, exempted from tax, because tax was being paid by the first supplier.
How much does the 10% amount?
7 lakh rupees, my lord. Only maybe the amount looks small, but for me it has become big, because for me it is big, my lord, because my position is that I don't have any this thing.
But how to direct him to take up the appeal without the pre-deposit?
By reading down the provision, that is the thing. And this question, perhaps long back.
That you'll have to then, there is already a division bench which.
Yes, my lord, I was there.
VAT Act, the word was entertained. Here the language is no appeal shall be filed. So there cannot
More
be any
stringent.
more stringent. No appeal shall be filed. There the word was entertained. Well, appeal, there is no bar in filing the appeal, but it could
There are
not be
several
entertained.
decisions. There are several decisions of.
Yes, my
Supreme
lord.
Court.
But this one decision that your lordship referred to, in that I was also a arguing advocate, my lord. In that case, this question was not answered, because the main question involved was the vires of Section 84 of the VAT Act. I have brought that judgment. There,
Financial constraint is no ground to challenge a constitutional validity of a provision.
no, so that I am not at all on constitutional validity.
But then if you say that there is any violation of principles of natural justice, when the original authority passed the order, that case where are your appeal grounds?
Appeal grounds in the.
Or in the writ petition, what are the grounds you raised on merits?
Like,
see, when you file an appeal, you should challenge the correctness of the order passed by the Joint Commissioner on merits.
Yes, I did.
Where are your grounds of appeal?
Page 79 does not reflect anything.
Writ petition is from no. This
writ petition will.
Page,
no, have you raised this grounds on merits also in the writ petition?
Yes, my lord.
Page. Or you do one thing, show the show cause notice.
Show the show
cause notice, your reply.
Show cause notice not annexed, subject to correction. Show cause notice possibly not annexed.
Maybe.
From that, we'll try to fetch some point. You file it, sir. Tomorrow you file it.
His answer to the show cause is at page 42.
We will extend time by 3 months to pay the pre-deposit. By that, at least you will be able to canvass the question, who is a pure agent, definition, etc.
That would have been my last submission, would have been that if I have no case at all, then kindly allow me a time to go before the
We will give you 3 months time.
3 months times to go before the original authority.
Appellate authority for making the pre-deposit, and appellate authority will decide the appeal on merits. And liberty will grant you to raise additional grounds.
Let that be, my lord.
This intra-court appeal. This intra-court appeal by the petitioner is directed against the order dated 11/6/2025, WPA 216020.
Sir, I want
In the said writ petition, the appellant had challenged the order passed by the appellate authority dismissing the appeal petition filed by the appellant, statutory appeal petition filed by the appellant on the ground that the mandatory pre-deposit condition be fulfilled under section 107 within bracket 6 of the WPGST/CPST Act 2017 has not been complied. We peruse the reasons recorded by the letters of the bench, and we fully agree with the such reason, as the appellant cannot bypass the statutory remedy, cannot bypass the statutory condition, which is just been held to be mandatory.
for the state and
However, taking note of the fact that taking note of the submissions of Mr. Khan, learned advocate appearing for the appellant, that the appellant is undergoing a severe financial crisis on account of various factors, we dispose of this appeal with the following direction. The appellant shall effect the pre-deposit as required under the statute within a period of 3 months from date. And if such deposit is made, then the appellate authority shall entertain the appeal petition and decide the same on merit and merits and in accordance with law, after affording an opportunity of hearing, personal hearing to the authorized representative of the appellant. However, if the appellant fails to comply with the above condition within the time prescribed, the benefit of this order will not inure to the appellant, and the appeal would stand automatically dismissed without further reference to this court. With the above observation, the appeal stands dismissed.
Serial number 10.
the flex টা কত?
10.
Kunal physical copy.
Kunal Mondal.
My petition, my lord. Lord, here the petitioner has filed a return, Lord, whereof 8 lakh of rupees odd ITC has been excess availed, my lord. Subsequently, my lord, as per section 44, rule 80, my lord, it was amended and return in 9 was filed, whereof this was corrected, my lord, ITC. My lord, the allegation upon me was that I have availed excess ITC from the department, my lord. And my lord, as because all the notices were in the additional notices tab, my lord, it was not taken care of, my lord. Subsequently, we filed an appeal. Now, my lord, the appellate authority, in spite of the fact that the annual return has been filed, my lord, appellate authority has not taken cognizance of that and has confirmed the order, my lord. My lord, the order of the appellate authority, my lord, also comes on to page number 72, my lord. In fact, my lord, before that, my lord, page number 83 is the annual return, my lord.
You could have rectified the mistake by filing an annual return.
I have.
But the
Page
appellate authority.
Page number 83, my lord.
83.
83. But this is the annual return.
Appellate authority says you have not filed.
Well, it is filed. Well, this is the annual return, my lord. And in page number 85, my lord, the ITC availed, my lord. My lord, column number 6A, my lord. Page number 86, 85.
85.
6A. My lord, amount of input tax credit availed in form 3B, my lord, is 1270, my lord. and B is inward supply other than import and to a liable to reverse charge, but includes services received from SEZ, my lord. ITC is 450, my lord, 4,50,000 rupees. And here, my lord, next page, my lord, column number J. Minus 819,823.
But why does he say you are not filed? You come to page.
My lord, it's 72. 72. Yes, my lord, this is how is dealing with this, my lord. My lord, I come to the merit of the case, that is whether the grounds on which the discrepancies are true or not. The applicant GST number is this. He is also stated that under GST number this, in the name of the petitioner from the same address was issued by the application. My lord, I have dealt this issue in paragraph number 1 of my petition. My lord. This is found that the GST back office portal that the appellant has availed excess ITC amounting to rupees 799,063, my lord, under heads of CGST and this under heads of SGST, my lord. Thereafter, my lord, he claims that there is a wrong declaration of output supply in 3B. The output supply as per the books and accounts from the period this was nil respectively, whereas the output supply declared in 3B is 15,17,983.66, this respectively. The applicant has got the opportunity to rectify the mistake, if any, by submitting the annual return, my lord. Annual return has been filed. It is in his portal, my lord. It is available with him.
But no such rectification was made.
My lord, I have proved before your lordship, my lord, in page number 80, 85, my lord, 85 and 86, that the rectification was made.
Then why he should say so?
Well, he has not gone to the without application of mine, my lord.
And what does the original authority say?
My lord, original authority, my lord, does not say anything, my lord. Only as because I did not give any reply, my lord, they did not
any
deal with
instructions you have got.
Well, there are two things. Well, he was having two registration numbers from the same address. One would find the penultimate paragraph. The appellant's page 72 GST number is so and so. It is also stated that another GST number in the name of the petition from the same address, which is impermissible. I do not know how the state, any authority had given this, because under 25
because one registration number is ends with 1Z7,
and that GST return is in respect of the same. I have checked it up. That is, I have checked it up.
Well, whether this was the issue upon which the so-called notice was issued, my lord.
What was he was doing, my lord?
But so-called notice was issued on.
But how to register?
My lord, why, my lord? My lord, paragraph number 1, my lord, of the writ petition, my lord. With reference to the above, the petitioner would like to submit that for the purpose of carrying on the business in the state of West Bengal, your petitioner is duly registered under GST Act 2017, holding GST number this. It is pertinent to mention that as your petitioner was having certain problem migrating from the VAT regime with the said GST, and your petitioner, as per the advice of his tax consultant, applied for the fresh GST and registration from the same address. The number allotted was this under composition. It was not under regular. This was regular, other was composition. He could have, second of whatever they say, both it is from Bahrampur charge. Both the registration was in the same charge. There are odds, say, 12 to 15,000 registration over there. They could have gone and checked it out. Whether I have availed it, as because there is a composition dealer, I cannot take any ITC from there, my lord. And my lord, in the order, my lord, in page number 73, my lord, the appellant has got two GST number, my lord. If the data in relation to the business regarding outward supply / inward supply of the two separate GSTN number of the petition interchange, it means that appellant is not maintaining proper books and accounts properly and regularly, my lord. My lord, he is not upon myself having two registration. He is telling that, my lord, I have interchanged as because the accountant has wrongly put the figures as regards to the sale and purchase of the other GSTN in this GSTN, my lord. I am not maintaining a proper books and accounts, my lord. That means, my lord, the books and account was in front of him. He could have verified it very well. and the portal was in front of him, my lord. He could have entered into the portal and but checked it out whether I have availed that ITC or not.
But you did not point out this before the original authority.
It was, my lord.
65.
It was.
Ground in the appeal. Kindly see D. His ground in the appeal. He has said that it was interchanged. It is his ground.
Yes.
In the appeal.
Yes.
No, that he admits. But he says that he has rectified it in the annual.
That rectification is not reflected in his appeal, subject to correction. That memo of appeal, it is not reflected.
My lord, 9
That
is
reflected in
my lord,
the
9 is in their portal.
My lord,
Well, they ought to have verified it. 9 is in their portal.
Correct, sir. But then it is a self-assessment procedure.
My lord, this allegation is coming for the first time. My lord, kindly takes the note of this one. As because this is in the SOCOS notice, this allegation was not over there. Final draft, my lord, final appellate of the authority's order, my lord, this is coming up for the first time. Or otherwise, I would have dealt with this.
No, the show cause notice was only on the ground of
Mismatch.
discrepancy.
Mismatch. Only ITC. Only ITC. That excess ITC has been availed. Page number 45.
Where is your reply to the show cause notice?
I could not give as because, my lord, it was in the additional notices tab, my lord. I did not, my lord, there are 2 tabs, my lord. There are different tabs, my lord. One is for the orders and notices. And there is another tab, additional notices and additional orders, my lord. My lord, I missed it, but within time I saw that it has not been reported, my lord. The reply has not been given, my lord. Subsequently, I filed an appeal clarifying that this is the mistake as regards to the excess availment of ITC is this reason, my lord. They could have gone into my accounts. They could have gone into my.
No, in the appeal grounds, have you said that this mistake has been rectified in
No,
the annual return?
My lord, in the annual return, I did not mention it, my lord, as because this was not the subject matter of concern, my lord, in the SOCOS notice. This has cropped up in the final appellate order. And if he is writing, my lord, that it has not been rectified, my lord, in that case, he has gone to the portal to check it out, my lord, but haven't taken the pain to verify it.
On what date show cause notice was issued?
My lord, page number 45, my lord.
You say some 30 days time was not granted.
My lord, SOCOS notice was issued on my lord 12/12/23, my lord.
But my instructions are on this.
And my lord, page number 48, my lord.
I could both of the
First,
first.
Well, and the date of personal hearing is not also mentioned, my lord.
My lord, this is my instruction as regard to the adjournments. Twice it was adjourned for his a tender apology. I should have brought 2 copies. Tender apology. Just to show copy.
You didn't appear, sir. 2 notices have been issued.
Well, as per my instruction, my lord, I found this only in the portal, my lord.
But for the first time, the appellate authority says that he has not rectified his.
My lord, may I say this? My lord, kindly, why? My lord, would kindly come to page 71 of the order. But this is the foundation. My lord, he takes a ground, and I decide on that. That's why this is kindly see, my lord. These figures will match with para 72 last, but clause D. For that, the allegation in the impugned order that the petitioner has availed excess ITC amounting to rupees so and so each under CGST and
No,
SGST.
he accepts a mistake.
And Malat, he doesn't say he has rectified. This was the kindly see the figures matches. He doesn't say he is rectified. So Malat, once a SEC comes and says I have not rectified, it would necessarily means he has not taken steps to rectify it. But it necessarily means Malat he.
But then, what is the stand of the AO on this annual return?
That I have to take instructions.
You have not said in as many words.
My lord, I admit it. Well, this is from Berhampur, my lord. This is a better appeal, my lord. At least it is a better drafted appeal. Well, the language is sometimes these are horrible, my lord.
My learned senior friend is not teaching me properly.
I'll try. I try to get a class of you.
This intra-court appeal by the writ petitioner is directed against the order passed by the learned single bench, declining to grant any interim order, while directing affidavit in opposition to be filed in the writ petition. Since the issue raised in the writ petition as well as in this appeal lie in a very narrow campus, with the consent of the learned advocates on either side, the appeal and the writ petition are taken up for disposal and are disposed of by this common judgment and order. We have not ventured to examine the merits of the matter, but only on the technical plea. Show cause notice was issued to the appellant alleging mismatch. And that excess ITC has been availed. According to the appellant, they missed noticing the show cause notices which are uploaded in the portal and therefore did not appear before the authority and file objections to the show cause. This led to an order, ex parte order being passed under section 73 by the Assistant Commissioner, Berhampur. Assessee preferred appeal before the First Appellate Authority, who rejected the appeal. The Appellate Authority has noted the grounds raised by the appellant in the appeal petition, wherein it appears that the appellant has accepted the mistake with regard to the entries made under the relevant returns. However, there is a finding rendered by the appellate authority that though the appellant had an opportunity to rectify his mistake by submitting annual return, but no such rectification was made. Before us, the copy of the annual return has been placed. It is as rightly pointed out by the learned government counsel appearing for the respondent. This plea was not raised by the appellant before the appellate authority, and had it been canvassed in such form, the appellate authority would have taken note of the same and dealt with the contentions in accordance with law. The appellant was also not vigilant to submit the reply to the show cause notice. Thus, part of the problem which the appellant has been put to is on account of their own conduct. Be that as it may, if the annual return has been uploaded, as could be seen from pages 83 of the stay petition, then the authority can consider the same, more particularly when the appellant has an explanation as to why the mistake has occurred. Therefore, considering the peculiar facts and circumstances of the case, we are inclined to remand the matter back to the Assistant Commissioner, namely the adjudicating authority, for fresh consideration after taking note of the annual return which was filed by the appellant. Dated 30th September 2020. For the above reasons, the appeal as well as the writ petition are allowed. The order passed by the appellate authority as well as the assistant commissioner are set aside, and the matter stands remanded to the assistant commissioner for fresh consideration, who shall afford an opportunity of personal hearing to the authorized representative of the SSC, take note of their submissions, and in particular, the annual return which is set to have been filed, and lastly,
Well, this, please, Lordship, my lord, this, my lord, small indulgence, my lord. My lord, the appellate side was suddenly called, my lord. There was a mentioning, my lord, of one matter, my lord, which has not come in the list, my lord.
But this bench will continue 2 p.m. No, not today. My lord, only thing, my lord,
tomorrow, my lord.
We have filed a review petition for the state where we have some contention. What happened, my lord would remember in a Shingur work project, my lord had passed an order. Mr. Ankit was appearing in one matter, my lord. One part, all the parts have been complied with. The government who was concerned had paid the tax component, and Mr. Kanodia's client has paid to the service tax. Now, another part was that was a double recovery because we had also recovered a part of it. My lord, subsequently find there was a challenge to that adjudication order by which these payments were made, where before division bench, my lord did not ask for any further or payments or deposit because 20% more than 20% was deposited. By this order, my lord, this 20% gets diluted. So it's a basically modification. We have filed it. I give the number. And I have some.
Yes, Mr.
Item 13.
State is not there. So I mean,
Lordships will be missed. We will miss lordships. We are already feeling this. We are already we are all are saying the same thing.
I'm currently in a training program. That's why I had to miss court.
Whatever lordship.
tomorrow will be there. This matter will be there. While the state is there, because state is a necessary party.
Yes. Who will appear for the state?
Mr. Sen, actually.
No, he's not been appearing. You inform them. Item 13.
Application, sir. Somrat.
It will remain in the list. Let you please inform.
HON'BLE Sen, that's Mr. HON'BLE Sen.
HON'BLE Sen, no.